Let me give you one example which illustrates very well the difference between US domestic tax law and US international tax law. And this comes actually from sort of a combination of two cases in which I was involved. You have a situation where two clients come to a business lawyer and they say, we want to start a company. We want to do a joint venture. We already have the capital. We're working on our marketing plan. Everything's fine. We're ready, really just up to start doing this. We really want to do it. So let me actually draw this. So this is domestic situations, right? You have a US corp, okay, which has cash. All right? Just cash, nothing else. Because this is year one. Let's say that this company was created in November. All right? Okay, year two. The company continues to have more than 50%. I don't know if you can read my writing. More than 50% of its assets as cash. So, more than 50%. Okay? In this example, nothing happens. Okay? For US tax purposes, nothing really happens. It's still domestic US corp owned by two US persons. They have, let's put it this way. Let's actually make it interesting. Let's make it 50-50. 50 foreign and 50% US. Okay? So we have, there's a 5472 requirement most likely associated somewhere here if there are reportable transactions. But nothing really happens to the entity itself. Okay? So this is domestic. Okay. So now we have a situation where it's a foreign corporation, okay? 50% owned US, 50% foreign person, okay? Same situation, first year, November, the company was founded in November, 100% cash, okay? Then we go into the second year. Same situation. Still more than 50% cash. Here nothing happens. Here, in the year two, this company will be considered a PFIC, a passive foreign investment company. And what this means is that unless an election is being made, and there are various elections, we're not going to get into the detail, but let's just discuss the default method of PFIC calculation. What this means is that if in this situation there is a dividend in year three, it will be subject to long-term capital gains rate. So, you know, basically your 15 to 20%, depends on the income level of your client. Possibly an Obamacare net investment tax of 3.8% on top of that, but that's a different story. Here, it's going to be a completely different treatment. If there is a distribution in year three, most likely I would estimate about 40% will be treated as ordinary income, and about 60% will be subject to 39.6% tax. So, just because this is US domestic, this is US international, just because it's an international, all of a sudden we raised our tax liability by about 20%. And a business lawyer who thinks that this is the same, you can see what will happen once a client gets a tax bill, right? Once he files the tax returns. Any questions on that? Anything clear? Everything clear? Okay. as clear as it can be. But yeah, it's definitely something to be aware of. And in the situations where I was involved, the business lawyer failed to advise about the difference. So, and unfortunately, once a PFIC stigma is attached, we call it the PFIC taint, you cannot get rid of it. Once a PFIC, always a PFIC. Okay, so you can get rid of it, not to get into too many details, but it will require deemed disposition of the shares. So in essence. So that's a very important illustration of how US international tax law may be different from US domestic law.